Thank you. Thank you for the few that are here in person because of COVID, and thank you to the other ones that are following on Zoom. Thank you for this very kind presentation. So yes, I did write something trying to be prudent because, as you know, English is not my first language, so I just want to make sure that I have a script. So first of all, I think that I was a little imprudent when I decided to deliver a lecture on jurisprudence and law. And the reason being that I'm not a philosopher who wrote a dissertation on prudence as a speaker that we had previously, nor am I here as an expert on that particularly, specifically American jurisprudence that is now so debated, especially because of the new nominations to the US Supreme Court. But I do know a couple of things about philosophy, and I am myself an attorney, as Dr. Stewart said. On my defense, a non-practicing one. And as it will become clear, I will speak here of a prudentia juris that is easy to grasp, even with a very minimal philosophical background, such as mine. Is a prudentia juris that is the backbone, in my opinion, of what every legal professional should be doing in his daily work, if we want that work to be in any way related to justice. I chose an opposition for the title of this talk. However, let me clarify from the very beginning that's not what I have in mind. Prudentia juris and law are not at odds. As Thomas teaches, prudence is the guide of all virtues, the virtue guiding all the other ones, and hence is a guide for justice. But between these two words, jurisprudence and law, there is, in my view, the relationship that there is between a mother and a son. This title, however, made you come here. You're following because of the title, so it was prudent, I would say, in a Machiavellian understanding of the term, from what we understood, if not Aristotelian. And then as a further premise, because attorneys love premises, and we just learn, you have 15 premises, then you get to the issue. What I would like to offer is a vision of the legal profession that cannot be immediately translated into practice, for sure. But it is true everywhere because it's rooted in the nature of things and in the very nature of human beings. So before I start, I was very prudent, at least in the fact that besides writing, I also made sure that I'm not going over 45 minutes. So I hope that that's not too much. So how did the title come about? Well, prudence, as you know, was the theme of our programming. But I was also forced to think in terms of opposition when facing for the 100th time the need to translate my CV. It was a very practical need. I attended law school, as every attorney, but my faculty is called Jurisprudence at the University of Padua. And then my Ph.D. is a Ph.D. in law, but again, from the faculty of Jurisprudence. So I started thinking, what is the difference here? Now, the theses, the dissertations that come out of the Department of Jurisprudence include jurisprudential work in the English, in the American understanding of the word. But that's not all that there is there. The way the word jurisprudence is used as describing the works of jurists. And it describes that prudential activity that I believe legal professionals are called to perform in their daily job. And that's true for lawyers, for judges, and for academics. Now, I don't want to waste too much time discussing the importance of different words, because even though it's very common today to think that words shape reality, I don't believe that. I think that there is a reality of things. But using different words does make a difference. And I think it's very evident, for instance, when we talk about abortion, or we talk about voluntary interruption of pregnancy. Do we talk about merciful cooperation in suicide or merciful dying, right? So words give us a sense of what it is that we're doing. Now, there is also something I learned preparing this paper. One never stops learning. It's true that my faculty was called Jurisprudenza, but this term is very recent. Recent, considering that the University of Padua was founded in 1222. Now, because it was founded in 1222 and it was called Universitas Juristarum, But then in the 18th century, it started being called the school of jurisprudence. So I said words can shape reality. And so I think that there is a reason to call our job jurisprudence, a prudentia juris, but at the same time, Italian lawyers are far from being jurisprudentes, right? So I'm not arguing that the name is sufficient. I'm just saying that it's a good start. Let's start with the right name. Let's start by naming things with the right term. And also, my reflections are the hairs of the reflections of a professor of philosophy of law at Padua, who is no more with us. But he talked about prudentia juris and the need to rediscover the virtue of prudence in the work of lawyers with reference to Italian law schools. So I'm not arguing, with one system or another. I think that this virtue is a virtue that is missing in the legal profession everywhere. So what I would like to say is that it's not a name, but it's a certain approach to the study of law and to the single cases under trial that I think is what we need to recover and to rediscover. What Roman law sources confirm is that arguing for the need of prudentia juris means that law students need to remember that there is something that adds to the static law. There is the knowledge and the experience of men. So I'm not talking about the natural law, so what comes before the law is a more general law, but there is the fact that there is a reality in front of you. There is the fact that whenever you're working as a lawyer or as a judge, you're talking about another person, and you as a human being know what it means to have knowledge of facts, what it means to be in control of one's action. So there is that part of experience. Now, that's what I think jurisprudence is about, and is this mix of knowledge of the static law and knowledge of human beings. But then there is another question I posed in the title, which is still possible to talk about the law and about lawyers as men and women whose desire and vocation is justice, so that do not only care about winning and about money? And this is something I asked myself while I was attending the annual Red Mass of 2020. Which is the Mass that opens the judicial year for Catholic lawyers, invoking the intercession of St. Thomas More. And I asked myself this because among the prayers, there was the one calling on all lawyers to protect life and dignity of the human person. Words that sound obvious to my ears, this is why I study law. I wanted to defend the big principles. And so have many other lawyers that I know. But these words and this prayer is so much at odds with the common vision of lawyers as sharks, or judges as bouche de la loi, that would just say what the law is, and including unjust laws. So are we seriously praying for them to do it right, or do we want them to do a right work? And this is also at odds with the idea that we just need to pack the court to get the results that we hold to be just. So can lawyers work for life and dignity? Can they find always the best way to protect these values based upon the existing laws? Or do they have to always defer to legal theories, authorities, school of thoughts? And the bad reputation of lawyers is not an exclusively US based thing. I'm sorry for lawyers, but it's true everywhere. In Manzoni's masterpiece, the Italian novel The Betrothed, which is famous now internationally because it's set in Milan, in a Milan that was afflicted by the plague. The lawyer's name is Azzecca Garbugli. And this name suggests that the legal profession is a form of sophistry, because the name means Azzecca is get right, and Garbugli means tangles. So he gets right the tangles, but that's all he does. Like it's only an art made of words. And this lawyer in the novel is the example of a coward. At first, he seems ready to help the protagonist of the novel, the young and Renzo, who's in love with this woman, but then he discovers that his enemy is the powerful lord of the land, and so he makes up all, the excuses and just decides that he cannot defend him. So it's just like the example of a coward and of somebody who submitted the law to power. And Dante condemned lawyers too, of course. He didn't condemn them all, though. He condemned those who used their tongue and their intellects without putting virtue first. If virtue was not their guide, he speaks of them in the 26th canto of the Inferno, where he also tells the story of Ulysses that leaves again from Ithaca and wants to travel again the world. And why does he put them there? Well, it puts what they are suffering in this circle of the Inferno is they are forced to live in a tongue of fire because they used poorly their tongue, like they used it in the wrong way. So Ulysses, in that case, used his gift of convincing his friends. He made them proud again and wanted, but it was the wrong counsel. So, however, Dante doesn't put all lawyers in that circle. So there is a sense in which the faculty can be used in the right way. So we can pray during the Red Mass and in other times that lawyers use their tongue well. There's no reason why they shouldn't. And the question that I posed again in the title was it ever the case that lawyers were good people? Well, in the US, among the 56 signers of the Declaration of Independence, 25 were lawyers. Of the 55 framers of the Constitution, 32 were lawyers. Now, unless we think that document, the one which gave rise to the nation that freed the world from Nazism, was not virtuous, which is unfortunately something someone believes, we must agree, I think, that law and virtue are not necessarily enemies. As said, in Europe, Dante did not condemn honest counselor, and Manzoni, the author of the Victories, was himself the grandson of Cesare Beccaria, who was the father of modern criminal law and whose writings even influenced the US Constitution and the Bill of Rights. Then there is the epic wisdom of Judge Solomon, which should also help us believe that a just justice is possible. And even if I'm not arguing that we need holy lawyers, good enough would be sufficient, a sufficient step forward. It is worth remembering that in addition to St. Thomas More, there is St. Francis of Sales and St. Alfonso Maria de Liguori, who were lawyers too. And then there is Venerable Giorgio Lapira, who assisted writing the Italian Constitution. So I think we can save the legal profession because the need for justice is inherent in human beings, more or less like marriage. We can kill it, but it will survive, it will resist. But we will have the lawyers that we want, the ones that we pray for, at the sole condition, and it's probably where I get to the center of my talk right now. After all these premises, I'm sorry, but that's the way I talk. The sole condition that we make it possible for the legal profession to be again a form of true philosophy. And by that, I mean an art that seeks truth, which is based on the profound knowledge of both man and laws, grounded on human experience and hence really guided by prudence. Now, let me break down the statement. True philosophy. Why? Well, when I say that the legal profession is a form of true philosophy, I would like to stress that the adjective true here comes from one of the oldest definitions of what jurisprudence is in its fullest meaning, the study and the dedication of one's life to the law. Now, bear through this long Latin quote with me. It's from Ulpian, and it comes from the first book of the Institutes in the Digest. So it was 530 Anno Domini, so the 6th century. This is the quote. Iuri operam daturum priu nosse oporte, unde nomen iuris descendat. So he who wants to devote himself to the study of the law ought first to learn where the word ius comes from. Est autem a justitia appellatum. It comes from justice. Nam, ut eleganter Celsus definit, ius est ars boni et equi. Indeed, as Celsus elegantly defines it, the law is the art of the good and the equitable. Cuius merito quis nos sacerdotes appellet. That is why some have called us priests. Justitiam namque colimus, et boni et equi notitiam profitemur. For we worship, we pursue justice, and we openly say what is good and what is equitable. So we deliver the news, actually, literally, of what is good and what is notitiam profitemur, of what is good and what is equitable. Ecum ab iniquo separantes, licitum ab illicitum discernentes, separating the equitable and the inequitable, distinguishing permitted and forbidden. Bonus non solum metus penarum, verum etiam premiorum quoque exhortatione efficere cupientes. Willing to make people good not only through threat of penalties, but also through encouragement of rewards. And here comes, veram nisi fallor philosophiam non simulatas affectantes. So this is also, we do all these things, we separate the good and the bad, the equitable, because if I'm not wrong, says Ulpian, we pursue the true and not the fake philosophy. So on this definition, scholars of Roman law have argued for more than a millennium, since it's the 6th century. And I haven't read everything that has been said. But side note, Roman law is mandatory in Italy in the first year, and we don't need it to understand our codes, but I think we need it to become jurisprudentes. But what is particularly interesting of this distinction between the vera, the true philosophy, and the fake philosophy, is a reconstruction that a professor of Roman law, Giuseppe Falcone, made of what Ulpian had in mind when he tried to say, you know, what does he mean? Why are lawyers the true philosophers? So the convincing reconstruction of this professor is that Ulpian was answering to some of the critiques from Cicero and from Seneca. And Cicero and Seneca, in different ways, were trying to say that basically lawyers had become sophists. Like they started just to use the words for the sake of words, and therefore they were not pursuing knowledge anymore. In this definition that that Ulpian gives, before we go to the true philosophy or the fake philosophy, there is something that's taken for granted, which is law is, the legal profession is a form of philosophy. So it's not a technique, of course, it doesn't make things, but it's also not a science. So the German word for the law school is Rechtswissenschaft. So it's like the science of the law. But law is not even that. It's an art. It's a prudential art. And it's a philosophy. It's a truth-seeking process. And again, it's the real one if done. It's the real philosophy if done well. So I think that this is also the first rejection of positivism, the way we know it. Now, this is not the case today. If it were that, today, if the law today was a way of studying philosophy, then I would not understand why Russell Kirk, whom I adore, in his Politics of Prudence writes, he's encouraging students to study law, to become legal professional, but he mentions their need to endure the boredom of law schools. So why boring? They're boring because they are a memorization of statute and of laws, of precedent. But if they were a form of truth-seeking, why the law is like that? Well, because it's rooted in the nature of human beings, then probably it would become much less boring. And at least that's how I studied it. I think, if by jurisprudence we means the ars boni et equi, and that ability to distinguish what is inequitable from what is inequitable, that's anything but boring. Probably, however, what we study today everywhere is just this hierarchy of laws, and assuming that a legal system doesn't have any contradiction and holes that we need to fill, it's complete. But this hierarchical form of thinking of the law, which excludes the human element and experience from the picture, does not need priests to be performed, as Ulpian says. We call them priests because they can do this. But even a computer probably could just work with a hierarchy of laws, provided a good level of sophistication and the right software. So the computer could become an effective judge. As we know, this is not the case, and I think we all hope that we will never be judged by an algorithm. And why? Because the algorithm doesn't get who you are and doesn't see why you did what you did and why or you didn't do what you didn't do when you were supposed to do. So prudential judgments do not imply the absence of fixed rules, of axioms, of theorems. There are some unchangeable exceptional, sorry, here's where my non-English not as a first language comes, but okay. Some exceptional less rules, and there is logic, but that's only one part of the equation. In the realm of law, the general rule is you shall not kill. And it exists, it will always be applied, but whether the killer was in power, full, diminished, to control his actions, whether he wanted to kill or prevent another person from doing something else, that's something only the judge, the jurisprudence of that case, shall and may determine. And what is true in what case is not true in another one. Now, from my short but true criminal practice, I can say that the experience is, in a case, in the position of the dead body, in the actual functioning of a traffic light that was not respected. But what if it didn't work? And then led to a fatal accident. But that's what the lawyer needs to be looking at and the judge needs to be looking at. And that's what prudence is. Even, for Pieper and Pieper definition, prudence is not only the eye that looks forward and looks at what the laws and the reasons are, but it's also that eye that looks back and looks at the action and at facts. So it requires experience and a love for experience. So it's a form of true philosophy of love for knowledge, a knowledge that is very human. And I know that I'm displeasing many if I say that we cannot even say that a doctor that administers a medicine that shortens the life of a patient, it's not always wrong or always right. I'm on the pro-life side at all times, but there aren't fixed rules. There is the rule of the case. And as we had doctors here speaking, and there is no one size fits all. Unfortunately, the same is true for the law. The law has some rules, but then it will come down to what that specific person on the judgment deserves or doesn't. So, if prudence is a virtue that enables us to make the right choice and to act based on the specific circumstances, and if regarding the law, it is a virtue telling the judge what is the just and the equitable in the present reality, the one under trial, then jurisprudence cannot mean the mere knowledge, as in static knowledge of the law. It could only if we define law, use, as the necessarily and exclusively just law of the case, as Ulpian seems to be doing. Now, I agree with Ulpian that work law is a philosophy, but we know it's not a truth-seeking process right now. Why isn't that the case? Well, the fault, again, comes from Padua, and at least part of the fault, and I'm here referring to Galileo Galilei, and I'm not denying Aliencentrism, don't get me wrong, but in a famous letter he wrote in 1612 on sunspots, there is this famous passage. He writes, we either want to penetrate by speculation the true and intrinsic essence of natural substances, or, he continues, we are satisfied with getting to learn some of their aspects. And he continues, I believe that to attempt at the essences is not less impossible, and in terms of efforts no less useless in the near and elementary substances than in the very distant and celestial ones. So what he's saying is equally hard to learn about the earth than it is about the sun. So let's just give up on that. Let's just not attempt to the essences, including the very earthly ones. Now, the result is that we only have mathematical knowledge and mathematical science, but the feeling is that men feel that they cannot know what is beyond mathematical explanation. So goodbye jurisprudence as the ars boniet equi. Now I would say that we can know the things that are not scientific. We only need to accept that it is a different form of knowledge. It's like being in love. We know we are, but there's no absolute formula that gets us there, that tells us this is true. A similar error, another professor of philosophy reminded me in my first year in law school, happened even before Socrates with Zeno after Parmenides, and when they decided just to stay, with one they could calculate and don't attempt the essences anymore. But Greek philosophy is not my field, so I'll leave it to others. Now, when Ulpian, I was saying, when Ulpian is saying this, our philosophy is not a form of fake philosophy, and I need to respect the prudent promise of the minute, so I will. When he says that it's not a fake philosophy, what was he referring to? So Professor Falcone, in this paper he wrote in 2004, he credibly holds, from what I read, that Ulpian was answering to Cicero. And for Cicero, the true and elegant philosophy was what he called also the bene vivendi disciplina, so the discipline of living well. For Cicero, that was the part of philosophy that looks at human behavior and at the good mores. In other words, it's ethics. And it's a Stoic ethic for Cicero. So Cicero, Falcone tells us, opposes this bene vivendi disciplina, which is the vera philosophia, so the true philosophy, to Epicurean philosophy. So it's then worth noting that most of Cicero's critique of Epicureanism was precisely an attack to its incapacity to talk about justice. Cicero held that Epicureans had no right to speak of honestum, and that their followers cannot really call it a justitiam, they cannot follow justice. Cicero's vera philosophia then cannot but be the Stoic one, where virtue, so we all remember the difference between the Stoics and the Epicureans, but the Stoic ethic is the one where virtue is the end, and it has to do with honestum and justice, and which are abstracts but are also very real concepts. So this is also what Ulpian had in mind when he's writing the definition. So when we are speaking of the true philosophy, Ulpian cannot be speaking of an instrument that is meant for the maximization of pleasure. For Ulpian, the work of the law is oriented towards virtue. If we look at the present day, however, I'm not surprising anybody if I say that the situation is far from the one Ulpian describes. Today, laws and justice more generally throughout the world are bent to satisfy the immediate desires of individuals, regardless of any analysis over their virtuous or non-virtuous nature of that desire. It is the positive law, it is power that decides what rights are, and it is desires then that deserve legal protection, the claim goes, because their satisfaction of these desires will cause pleasure. Or, as it seems to me even more the case, they must become law, these desires, because if we leave them unsatisfied, then there's going to be pain, suffering that allegedly comes from leaving a desire frustrated. Then, to further prove that Ulpian's concept of law implied virtue, Falcone also notes how Seneca expressed ideas in many ways similar to those of Cicero. And in particular, Seneca held that those who dedicate themselves to the little questions, to the sophismata, do not improve their lives. They are not practicing any true philosophy. The true philosopher, for Seneca, is superior to human vicissitudes and does not change according to the conditions. This kind of constancy cannot come from the petty tangles and from sophistry. There the soft plays, but doesn't get any better. It actually brings philosophy down from its original prestige. And then there's one passage that I find very interesting in Seneca. In one of his letters at Lucilium, 108, he also says that those who teach not how to live well, but how to dispute, teaching ambiguities, syllogisms, and quibbles rather than what is honestum and rectum, they transform philosophy into philology. Now, doesn't this sound familiar? Isn't some of the contemporary conservative criticism of originalism precisely an attack to the idea that the text, detached from unspoken and implied principle, should provide all the answers? And I know, just to be clear, that originalism and textualism are not the same thing. But I know, at least based on the conversations I had with US scholars, that while most social conservatives are scared of the common good constitutionalism recently spelled out by Professor Adrian Vermeulen, which would basically do away with the need to find the answers in a written constitution, they are also aware that originalists are gradually losing any ability to defend principles as basic as the family or the non-disposable and inherent dignity of human life, from conception to natural death. And I'd say that originalism will inevitably lead us to fail if what it means is the acceptance of the idea that law is a science rather than an art. If we do not attempt the essences, we're doomed to fail if we do not see how every law and every legal decision must find its legitimacy not against, but beyond the existing text. In natural law, on the one hand, but even more so, as I said, in the reality of human experience. Ought and being, basically, are in deep communication. And yeah, probably Hume got it wrong. And from what I remember of philosophy, it's a rejection of nominalism that I'm basically trying to argue, and then there is some truth in reality. Now, I don't think it's a chance that Professor Ark's famous book, Beyond the Constitution, written 30 years ago, continues to be, and perhaps now more than ever, at the core of contemporary scholarly debates in the US. The textualist temptation, the sophistic understanding of the law was equally strong in Europe. And ultimately, Hans Kelsen was born in Austria and not in New York City, although he did end up in California. As mentioned earlier, Rechtswissenschaft, law as a science, is the name of the German school of law. And it was precisely with reference to the European and to the Italian legal system that my professor, Professor Francesco Gentile, argued for the need of law schools to rediscover what prudentia juris means and demands. It is in light of his teaching in Padua that I formerly stated that this true philosophy is grounded on the knowledge of both laws and men. In an article titled Prudentia Juris, Professor Gentile referred to Ulpian's maxims, and in his writing he made several references to a variety of Roman sources and discussed, besides the Roman genius, he discussed what is the true role of lawyers. And the lawyer's work, Gentile says, is in the indicative, not in the imperative mode. I like this passage very much. The imperative of the law, of the statute, is necessary because we cannot give to each his due if we do not know what it is that one is due. But command is necessary, not sufficient, once we are facing the actual conflict between the two litigants. As Gentile beautifully wrote, in order to re-establish a relationship between the plaintiff and the defendant, the new imperative, which will be the one issued by the judge, right? So it will be the imperative coming from the judgment, which can then be enforced, cannot but develop from an indicative, from the reality. It is an ought that derives from what is. Like law derives from natural law, and that is the just law derives from the natural law because it agrees with reality. So the solution of the single dispute, the law of the case, will be the solution if it corresponds to the reality of the case. So the work of the lawyer, Gentile writes, is to transform the conflict into a controversy, and this is the trial. And in these terms, what is just will not depend, as it was already for Cicero, on the commands of the prince, as adultery and theft could become law. What is just will depend on the nature of the things in front of us. Once a human relationship is broken, the answer, the true legal answer that will reestablish the order, is not the one that is more powerful. The true order will again exist only if that one established by the judge conforms to the reality. And I think that it's clear if we ask ourselves, why do we have courts? Why don't we hire bandits to win a case? Some do. Why aren't we equally satisfied if we win with a trick rather than winning via fair play? Why do we demand not a specific electoral result, but a fair process? Because my answer is, justice is a reality for us. It's not just an abstraction. We need it. It's in us. It's like beauty. We recognize it. But how do we go then in practice from the indicative to the new imperative? Not by logical deduction only, There is no constitutional premise that is sufficient for that. And the genius of Roman lawyers, Gentile wrote, and I would agree again, consists in the fact that they showed us how justice always requires dialectic. It is brought about by a truth-seeking process that is Socratic in its nature, as revealed also by several other definitions found in the Digest. The use is always found starting from and within the nature of things. So there is this Latin saying, narrami factum dabo tibi jus. You tell me the facts and I give you the law, but it doesn't only mean I'm the expert here. It's tell me the facts. I need to know the facts. I need to know what the reality is. There isn't just a law, an abstract law. Is it right? Is it bad? And this leads to another very famous definition of opium, which is probably the most important definition of jurisprudence, which is jurisprudentia est divinarum atque humanarum rerum notitia justi atque injusti scientia. So jurisprudence is the knowledge or acquiring the news over divine and human things, and the science of what is right and what is wrong. So it's exclusively on the basis of real knowledge, of the familiarity, of the experience of human and divine matters, that we can discern the just and the unjust before us. The law is not enough. Roman lawyers acted like the common law lawyer supposedly acts, starting from the cases. But the modern fear of the unknown led to the Anglo-Saxon version of positivism, which makes precedents look exactly like civil law statutes. In this sense, and now I'm going to provoke somebody, how prudent was a decision like Roe v. Wade? How much did it have to do with the reality lived by that specific woman? The answer is straightforward if we remember that Norma McCorvey, Roe, was completely out of the picture when Roe was decided, which is why there was all the part of the judgment dedicated to the mootness of the case. She wasn't in front of the judge. Again, what's the prudence when we have the standing of Planned Parenthood to argue pro-women? What's the reality of the case? With reference to the Italian system, I would argue that there was a very similar problem and an absence of prudence in the case that led recently to the partial criminalization of assisted suicide. Because while we might argue, even though that's not my position, that the single judge may forgive some cases of assisted suicide, to go from there to declaring the general unconstitutionality of a criminal ban is a step in the direction of law as a science and as an abstraction, and of a law being capable to contradict the reality of things, which is thou shalt not kill. So prudence has two faces, one that looks at the objective reality and the other one aimed at bringing about justice, as we said before. And as Gentile pointed out, the first part implies the availability to listen, an objective understanding of reality in front of us, and there must be no prejudice, no ideological or scientific a priori. The lawyer, the legal professional, the lawyer or the judge must be open to the radical complexity of reality, which exclusively a true love of truth, philosophia, can convey. And there is also the acknowledgement of the risks of a decision that is always contingent, always in doubt, because human reason is not capable of absolute certainty and absolute knowledge. Again, can there be this kind of prudence in international resolutions discussed at the UN level, far from people and real cases? I do agree that UN resolution can state fundamental rights rooted in reality, and they can promote general policies, but international bodies are so far from the litigants that they will never be able to administer justice in these terms, in the prudent understanding. With reference to judges, Cicero in the De Officiis recalls an ancient instruction for the judge, a prayer from the plaintiff that said, "Do for me all that you can while preserving your good conscience." So as we do not want lawyers, as said before, to be bandits for us, also from the judge we desire a sentence that is just. So let me then close, following this specific idea, with a passage taken from the words of an Italian judge who was recently proclaimed a servant of God. His name is Rosario Livatino. He was killed by the mafia on his way to work in 1990, and there is an ongoing process of beatification. So Livatino wrote very few things, but he wrote this, speaking of the role of the judge, he wrote, I'm quoting, "The judge's duty is to decide, and deciding is to choose. And it is precisely in this choosing in order to decide to put things in order, that the faithful judge may find a relationship with God, a direct relationship, because administering justice is to realize oneself, it is prayer, it is dedicating oneself to God, a direct relation that passes through the love for the person under judgment." And then he continues, "And this duty will be lighter if the judge will humbly acknowledge its weaknesses, and if each time he will present himself to the society that gave him so much power, willing to and aiming at understanding the man in front of him, and to judge him without a Superman attitude, but with constructive contrition." And the last passage. "Once more it will be the law of love, the vivificating strength of faith that will solve the problem. Let's remember Jesus' words to the adulterous woman. Let him who is without sin among you be the first to throw a stone at her. By these words, he indicated the deep reason of our difficulty. Sin is shadow, and in order to judge, there is need of light, and no man finds himself in absolute light." End of quote. Now, the law of love. How can the law of love be defended in the world we live in? Well, my answer is in the same way that life and dignity can be defended. We either realize and accept that they exist, regardless of what the positive law says or how well we can define them, or those prayers, the ones of the Red Mass, will be absolutely meaningless, and we cannot blame lawyers for that. Thank you.
Thank you very much. You gave us a lot to chew on, and Q&A, just to let those who have joined us via Zoom know, Q&A is open. I have the chat box open, and we'll be looking for questions there. And then also we have some people who have joined us in the reel, and they are permitted to ask questions. I want to exercise the prerogative of the chair by getting a question in first. I subject nearly all of our speakers to this, but my question is that it seems like what you're describing, jurisprudence is the virtue that operates within certain boundaries, and the boundary conditions there are, on the one hand, if we're going to have order, if we're going to have justice, we need order, and order requires rules and forms, right? So sometimes it seems like what justice requires is a pretty straightforward application of, here's the rule, you broke the rule, you get punished for it. But then at other times, right, because we have not only order, but equity, we say, well, you did break the rule, but there were these conditions that attached that either mean that the rule wasn't in effect, right? They're conditions outside the boundary conditions of the application of the rule, or you were serving an end even higher in that moment than order, and so we perhaps forgive the transgression. So, for example, some good friends of mine and I were visiting scholars overseas at a university overseas, and the two of them were a married couple, and the wife of the married couple was pregnant, and so on the day that the baby came, early in the morning, we were being overseas without a car, so the next door neighbor took them to the hospital. 2 weeks later, in his mail showed up a speeding ticket that he acquired taking this woman to the hospital. So, I mean, that has always stood out to me as a good example of a speeding ticket that you shouldn't have to pay.
Yeah, I agree.
But of course, it was the machine. It wasn't even an officer, right? It was the camera.
Yeah.
And the camera exercised no judgment, right?
Isn't that what we're... Yeah.
The camera simply took a picture of who was going too fast. And then the computer mailed a ticket to the people that the camera took a picture of. So my question then, that's a long wind-up for the question of what are some of the tools that lawyers need and acquire when the professor says we need to move away from the Wissenschaft view toward a practical view? What are some of the practical tools, because you've been a practicing attorney, that help an attorney navigate between the poles of the need for order and the need for equity?
It's a great question. Of course, you ask yourself this while you're writing this and while you're working, but I think it's the same answer that I have I think that a doctor would answer in the same way. Do you care? If you care for the case, there is a rule. I mean, I'm thinking, of accidents that can happen during work, and you have to wear all the protections, and so you need to decide, was this person at fault, wasn't it at fault? But if you care about the person, the one that injured himself or the one that was responsible, you just look at the details. So what I was trying to say is we can't say, so law can be wrong, right? But let's assume that we have just laws. The laws we have are the ones we're fine with. But that's just one step. It's as you said, you wouldn't get, how many cops in 3D would have given the ticket to the person that was driving very fast to get to the hospital? It would be hard. And I think that it's hard because that person would be considering, who am I speaking to? What am I, so as a doctor does it, I think that that's the exact same thing with lawyers and with judges. I'm not arguing, for instance, it's important in the criminal law to have clear limits of the sentence that the judge can give. And I'm not arguing for wider freedom, because I don't want the judge to be, but still, while you're doing it, you're not being an ideologue that believes, abortion is always wrong, or, abortion is always right. No, you're looking at that person, at that single decision, and you might have decided one thing the day before, but then the person in front of you today is another. So I think it's a matter of caring for it. So I don't know what I would teach to the, in law school, just saying, look at the faces, but it's not just what was the precedent or what was in a civil law country, what was the law. If that answers.
No, that's very helpful. So we've got an online question. Dr. Orlandi, what is that principle, truth or philosophy, as you mentioned, needed for law? That is, you mentioned briefly that you think there are unchanging laws, yet you also mentioned that there's no one-size-fits-all approach that works. So how do you reconcile these two claims?
There is no one-size-fits-all doesn't mean that there is a relative understanding of what is just. It just means that, is what I said before, is like a cure for disease, right? We know that that's the cure, and the opposite is not going to cure you. But there are instances where it's worth, continuing, even if the process is difficult or there are other cases where it's better. But it doesn't mean that the opposite will be a cure. Mm-hmm. So it's not a relativistic understanding of it. Is you have to combine, and so I'm never going to teach. I don't know. I'm thinking of you have children, so you're never going to teach your children, the opposite rules of the things. But you're not going to get angry all the times in the same way because of the things you mentioned before. They're not always, maybe that day, they're very tired, or that day, they were exposed to something they really don't like, and they were very good in doing it. So, would you punish them in the same way? No. And this is always a consideration that has to be taken with the things in front of us. Justice is one thing, but prudence needs to join that. Justice doesn't change, but prudence needs to lead it forward and to apply it to the single case. And again, I hope I answered. But
I would think that perhaps in practice, a lawyer can give more scope to jurisprudence in the way he counsels his client and how he tries to settle with the other side. Outside of the courtroom, there's a lot more freedom to have a settlement than when you get in the courtroom.
So I'll repeat that just so everyone online can hear. So the question was to react to, it seems like one venue for prudence is that an attorney has a lot more latitude for in how they guide their clients and in how they negotiate with other parties, particularly in civil matters, in order to settle, and that is a real arena for the exercise of prudence. Is that a fair restatement? Yes. Okay, good. There you go.
I certainly agree, although I also have this view of the trial that maybe is, I think when I think of the trial, I always think of the Greek tragedy and how the first trial, not the first, but like the trial with Oreste killing his mother. And after he kills his mother, he's persecuted by the Furies that don't give him rest. And then he needs to go in front of the goddess, Athena, goddess of reason. And the goddess of reason establishes a trial for him. So the only thing that will put an end to his conscience, his own, so it's not a problem even with the other person, is my own need for justice. Like, I know I did something wrong. So yes, for sure, there is this thing of like having private settlements, but even in the trial itself, going to trial can be, and there is a reason why lawyers have rules of fair play within the trial. You don't trick the other to win, because there is a sense that a law of reason should guide it all. I think we see it, you mentioned, having this talk today had a sense, in light of the elections and prudence and law, and but we are waiting. Like, we want to know what the courts will say. Like, there is a sense in which that will make us, settle the questions. If we had to settle them in another way, it would be hard and violent. So, I see a role of prudence, including within the trial. I think that the trial is a magic gift of reason. It's incredible how much it means for us to have an answer coming from the third party and following certain rules.
My question regards the process of lawmaking. How important or essential is it to you for a lawmaker, say a dentist that gets voted into office, not to make light of the profession, but someone who maybe doesn't have the kind of understanding or education of jurisprudence or philosophy of law or just philosophy in general. So when they get voted into Congress, and then they're the ones in charge of making some sort of law, some sort of change for their constituents, they have to look at their constituents because they were voted into office, but at the same time, they themselves might not necessarily know how to navigate the process of law, and it's more of a population appeasing rather than a desire for truth, as you mentioned. How do you reconcile the fact that there are people like that don't have a background in law, philosophy, or some sort of like liberal arts that get voted into office, and then they make those laws that can be controversial, and we're stuck with those laws for X amount of years, and then we have to repeal them, and it's messy, and the social conscience has to change. What do you say to that?
I don't know if you have some specific laws in mind, because your question means like you're referring to something in particular. I would say this: I don't like the government of experts the way we interpret it today, but I do believe, as the Republic and Plato, and I do believe that there is a role, like that certain people are the ones that should, there are the ones that should be the guardians and the military, and then there are the ones that will be the doctors, and then there are the ones that are the guardian of the city, and then the philosophers that will decide what the laws, the just laws are. Philosophers not in the not the post-modern deconstructionism. Probably that will not help to have good laws. They will just make our life easy, because they would just questioning, what is a law, and okay, fine, clear. But philosophy meant as the good of the good. I mean, political science in that sense. The good of the polis, and if not necessarily law, legal thought. And I do believe that there is a benefit in that. So I'm all for people in office that are just great entrepreneurs, and so they showed us they can make it unless I trust them. But then when you have to write a law, they have their staffers that have all their brilliant degrees from the best universities in the world, and they're the ones that should be writing the laws. They don't, they give you the mission, do this, and then you find the way. Right.
Good. Other questions?
So my question is, how can we as a society help to shorten the distance between these worlds? So how is this possible for us to help lawyers to pursue the true philosophy, as you were saying, and at the same time, not just for us, but for institutions as well?
Thank you for this question. This brings, so the question was, how do we make it possible to have these kind of lawyers that love the truth, and not only the specific lawyers, but also for institutions to get, so count to the Austin Institute. So no, but I believe it. I mean, coming from Europe and there was this beauty, we studied Latin and Greek in high schools, everyone for 5 years, and philosophy. And now that's ending there, sadly. Here there are the great books program, and I love them. And I think I was recently asked, I was in with some other legal scholars in the U.S. talking like, what should lawyers read to become the right lawyers that we want? And so I just went, great books. You only need that kind of knowledge. And I think that institutions, like the Austin Institute, but any institute that is also dedicated to providing students with some form of knowledge that is not practical in the modern understanding of the term, but is very practical because it goes to the roots of what humans are, what we need. That makes up, I think, for great judges in the future, amazing lawyers, and even, whatever profession you do, like, it just gives them, I think that is what is needed, just good tradition in this sense is a very good filter. And I believe, books that have survived for centuries for millennia, it's worth reading them, and there's probably a lot of truth there.
Good. We've got another question online. Would jurisprudence require a view of objective truth and moral objectivity? Would it reject moral relativism?
Yes. Can I just answer yes or no? But I think the answer is just yes. There is prudence means in the application of it's the application of the general law that is specific, but you do not thou shalt not kill remains thou shalt not kill.
Yeah, it seemed to come through in your talk in the references to Roman law, where the argument for jurisprudence is made from Cicero and Ulpian in contradiction to
sophistry.
Yeah.
Sophistry is the enemy. Sophistry is the fake philosophy. It's the one that doesn't teach, that makes the soul, go down and decrease and transforms the law into philology. Mm-hmm. And I found that, particularly revealing.
Good. Other questions? Yeah, Chris?
In the U.S., lawyers have a duty to zealously represent their clients. How does that fit in with this idea of jurisprudence?
Okay, so the question is, how does in the U.S., attorneys have a duty to zealously represent their clients? Where does that fit into the picture of the art of jurisprudence?
Thank you. This is a brilliant question. I think it fits very, very well, because zealously representing means really caring for them. So really caring for them means, especially, you're not going to lie. At least I think that it's true here too, but it's true everywhere. The lawyer doesn't lie. Should never do it. And I think for me, I like this question because as I was writing this, it's something that is true. If you speak another language, or read another, you there hear a lot of people that I know that speak many languages. A translation is never just words. You need to go into what did you really mean? Like, and I see the work as of the lawyer as the person that speaks the language of the law for you, for the client. So in speaking that other language for you, I need to be real and truthful to what you were saying. So the zealous that I put is in how well I translate this, but it's not saying what is not. It's not doing anything different from what you yourself would do if you only were out of the emotions or if you had the knowledge of that language. That's the parallel that I had in mind when thinking of these things. Is that clear? I see people nodding, so probably yes.
Yeah.
Are there any examples that you know of that you can comment openly about a time where out of monetary interest, financial interest, or corruption or whatever, where a lawyer tried to bend the law or tried to argue a case that would benefit the client even though it was probably wrong or illegal?
This is not a lawyer's job. It's sanctioned, disciplinary. That's not a lawyer's job. So if people do it, they're just not doing their job. It's like bribing a judge. You can't bribe. I mean, for sure there have been judges that have been bribed, but that's not being a judge. So and that tells you justice is rooted in reality, because the moment you know a judge is being bribed, you don't call it a judge anymore. You already know it has a different role.
So one of the things that that your talk made me think of was that in the U.S. and a number of other legal systems, but not in all of them, judges can't rule except on the case or controversy before them. So our Constitution actually requires that, Article 3. And so in a number of other countries, judges can, if the legislature passes a law, judges can pronounce that law is invalid and unconstitutional. That can't happen in the U.S. because there actually has to be a plaintiff. There has to be a case. There has to be a case before them. And I think part of your talk was making me, I've always sort of wondered about, well, which system's actually better, right? Sometimes, there are times when I think it would be good for the court to be able to say that law that you just passed, don't enforce that on people because it's unconstitutional. But on the other hand, I think you made a very strong case for why it's good that our system of government here, at least, and in other places, requires that there be an actual case, an actual controversy, people actually harmed by this who stand up and say, this is wrong, and let's go to the judge and sort it out.
Yeah, I feel like I've studied too many constitutional legal systems that I could now make a mistake. I know that there is a way in Italy to have a judgment directly in the law, but let's say that the last cases that I mentioned, the assisted suicide ban, you have a case in front of you. Same thing with abortion. You have a case, and then you say, oh, the norm in this case is not constitutional because it doesn't permit this specific thing. So I know that there is. I do believe that it is not the judge's job to judge the law itself until it's applied to the cases. I agree with you. There is some. Because of what we're saying, yes, you see it in the reality. Of course, if we knew, a law that is clearly unjust, but then, it's a majority. I don't know. It's a hard thought experiment to think about that in abstract terms. But.
We have another question online. Do you perceive a shift away from constitutional originalism posing a risk of potential violations of protections of religious freedom? And this is a question, among others, that is currently being wrestled with in Fulton versus City of Philadelphia.
I'm not familiar with this specific case right now. I think I am a big supporter of originalism and interpreted, not only rooted in natural law, but also with this eye to experience and to the reality of things. So I'm only saying that it's a bad interpretation a modern interpretation of originalism that is the one that is making us go in the wrong direction. Is probably Professor Arx would agree with this. You know, is what blinds us to what was so evident to the minds of the framers, that just because it's not spelled out, we cannot really write the rules of logic. There is no right to do wrong, right? Just to phrase it in the way Professor Arx would phrase it. I think that moving away from originalism, moving away from originalism could mean a thousand things. It can also mean brilliant things for a while. At the same time, I believe that this country has been, the best countries for some reason. So why moving away from the foundings? Why moving away from something that has worked? Try to, understand what is that made it work so well, and preserve that. Says the foreigner, but.
Well, let's give Dr. Orlandi another round of applause. This was a great. This was a great evening, a great discussion, and we're very grateful. And one more reminder to all of those of you who joined us online and in person to keep up at the website, through the podcast, on the newsletter, so that you can participate in all the things that the Austin Institute has to offer. Thank you all once again for your time and for being here, and good night.